Subscribe to get contents via mail. Purchase shorthand journals and more.
Power under Section 319 CRPC is a discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. It is not to be exercised because the magistrate or the sessions judge is of the opinion that some other person may also be guilty of committing that offence. Only where strong and cogent evidence occurs against a person from the evidence laid before the court that such power should be exercised, and not in a casual and cavalier manner. Thus we hold that though only a prima facie case is to be established from the evidence laid before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of his complicity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebuted, would lead to conviction. In the absence of such satisfaction, the court should refrain from exercising power under Section 319 CRPC. In Section 319 CRPC, the purpose of providing, if it appears from the evidence that any person not being the accused has committed any offence, is clear from the words for which such person could be tried together with the accused. The words used are not for which such person could be convicted. There is therefore no scope for the court acting under Section 319 CRPC to form any opinion as to the guilt of the accused. Under Section 319 CRPC, a person can be added as an accused invoking the provisions not only for the same offence for which the accused is tried, but for any offence, but that offence shall be such that in respect of which all the accused could be tried together. It is to be seen whether the appellants could be summoned for the offence under Section 498A IPC and under Sections 3 and 4 of Dowry Prohibition Act. The statement of PW1 both in the complaint and in his evidence before the court is very general, stating that he had given sufficient dowry to Shilpa according to his status, and that the groom side were not satisfied with the dowry, and that they used to demand dowry each and every time. In so far as the demand of dowry and the dowry harassment, there are no particulars given as to the time of demand and what was the nature of demand. The averments in the complaint and the evidence is vague, and no specific demand is arbitrary, and no specific demand is attributed to any of the appellants. In such circumstances, there is no justification for summoning the appellants even under Section 498A IPC and under Sections 3 and 4 of Dowry Prohibition Act.